Well, what we understand at this particular point, Naledi, is that there was a letter, or there seems to be a letter, that was written by Magdalene Munsami, who you would know is the legal representative for Kelly Khumalo, who was Senzo Meyiwa's then girlfriend. You'd recall that she was in a watching brief inside this court, but there had been a bone of contention with the other legal representatives who believed that she should not be here on the basis that it was expected that her client was to be a witness in this particular matter. And what we understand now is that there's a 3-page letter that has been addressed to this court. Judge Mamela says he has not read that letter yet. That's precisely the reason why this matter has stood down for a couple of moments. He's gone to read this letter. We're not sure what the contents of this letter is, but what we do understand is that Magdalene Munsami wants to be brought back to this court on a watching brief. And you would have heard during proceedings this morning, Advocate Zandile Mshololo for accused number 5 saying that she had not received the letter, while the state and the legal representative for accused number 1 to 4, Timothy Tobane, indicating they've received this letter. We'll certainly get to understand what the contents of this is about, but what I do know at this particular stage is that there seems to be a letter that was written by Magdalene Munsami pertaining to wanting to be brought back to this court on a watching brief on behalf of her client. So details certainly about that. We're hearing Judge Mamela indicating this morning he'd want to deal with that aspect first before we proceed with the matter this morning. As you correctly point out, the state's third witness in this matter, Senzo Meyiwa's friend Tumelo Madlala, expected to be back on the stand this morning, but it certainly seems like the court would want to deal with the aspect relating to this letter at the moment. All legal representatives have gone to the judge's chambers, and I don't think we're going to be very long in terms of dealing with this matter, because the judge has once again indicated he wants to deal with the issue pertaining to this particular trial and not any other sideshows that might otherwise come up in this particular matter, as we have seen. As you'll also see here, it seems like the legal representatives are coming back into court at the state. The advocate George Baloy, you'd see from the state this side, has already come through to court. We're expecting the other legal representatives to make their way through here any minute now. But of course, you would also look towards my left. I'll ask my colleague Neon Bandit to try and pan towards that direction. All the accused, of course, are still inside the dock at this point. What is also still outstanding, Naledi, as we mentioned in this particular matter, is that accused number 2, Bongani Ntanzi, who was pointed out by Madlala as one of the people that he says was inside the house at the time that Senzo Meyiwa was killed, indicating that it was Bongani Ntanzi that Senzo Meyiwa had pinned against the wall on the day that he was shot and killed. We're still waiting for an outcome on that particular matter. The bail application, of course, you would know, was heard in, all right, it seems we're about to begin. Unfortunately, I'm going to have to leave it there.
Yes, Mr. Baloy, I've gone through the letter. Basically, by Miss Advocate Munsami. Basically, it is the same request that was made at the commencement of this trial for her to conduct a watching brief as we proceed with this matter. You will all remember that I made a ruling and my ruling was even specifically referring to the time before her client features in the case. Because you will all know that when we call the witness to the witness stand, we even say to the witness do not discuss this case with anyone until you are excused, meaning that one witness who is on the stand or who is still to testify should not have insight of what other people, or more importantly, other witnesses have to say or are going to say when they appear before court. And I think it is within the same reasoning that the ruling went the route of refusing Ms. Munsami the latitude to come. So like I'm saying, my reading of the letter is a repetition of the same aspect about which a ruling has already been made. I do not know what is really itching for us to be facing these communications if we made a clear ruling. But that is my reading of the letter, and I'm going to give all of you the opportunity to state where you stand with the letter which you have by now all received. My other sense is that I'm not expecting a very involved address on the matter, in the interest of time. If you could briefly state where you stand with the letter that was sent, so that we can get busy with the main matter as soon as possible.
As the court pleases, my lord, the letter is dated the 1st of November 2022. The court has already indicated to the attorneys, and the request of the attorney stands on two legs. Firstly, she requests to be admitted to the proceedings, to be part of these proceedings. And over and above that, my lord, she's also asking copies of the case dockets in this matter, namely First Lawrence Case 636 of 10, 2014, and First Lawrence Case 3751 of 2019. She also wants to have sight of the transcripts of the proceedings, including the bail application of accused number 2. My lord, the state opposes the application. We point to the fact that the court has already dealt with this issue when it cropped up on the 11th of April 2022, and we attached the relevant portions of the proceedings. The matter was again dealt with on the 25th of April 2022, when the state requested that she should recuse herself from the proceedings. And we also referred to the court ruling wherein the court said the following, and we quote, "The concern we have now is that if witnesses testify before the client of the watching brief might be expected to express upon them, that system would not have been pure. I think we will discuss about the situation after the client of the watching brief will have testified, whether there will be a need to excuse the watching brief." And we attach the relevant portion of the record. We make the submission, my lord, that since the time when the court made this ruling until now, nothing has changed, my lord, that would necessitate this court to revisit the matter. We briefly deal with the role of a watching brief, and we refer to an article by a Nigerian counsel, Advocate Oluwaseun Damilola, and we beg leave to hand a copy of this article, wherein he deals at length with the role of a watching brief, but the point that he's making is this, my lord, that the role of a watching brief is more to sit in the gallery. He says a watching brief can only be seen and not be heard. And he says that the watching brief represents the victim of crime, and that when that witness testified, that's when the watching brief will be heard. And we make the submission, my lord, that what our colleague is asking for, it is more than what a watching brief is entitled to. We make a point that the ruling that the court made is obviously interlocutory, but it can be revisited only if the circumstances that have changed, and we make the point, my lord, that the circumstances have not changed. We make the further point that there'll be another watching brief, my lord, in the regarding a witness that the state will be calling, hopefully in this week. And that watching brief will be sitting in the gallery and just merely watching the proceedings from the gallery. And we're saying that this attorney is not entitled to be accorded greater rights than any other watching brief. And we point out, my lord, that the circumstances are distinguishable from, for instance, where there's a watching brief on behalf of the family of the deceased. Like in this instance, we do have a watching brief on behalf of the family, but they sit in the gallery and they merely watch the proceedings, and they don't even attend the proceedings daily. They only come if and when it's necessary. So we say, my lord, that she cannot be accorded greater rights than other watching brief. And we further make the point, my lord, that her situation is also distinguishable from where a watching brief represents a client who will not be requested to testify. For instance, where the watching brief is merely observing the proceedings, and we say her situation is different because her client will be called upon to testify. And we're making the point that in light of the fact that her client will be might testify, that it is undesirable that she should sit in the proceedings. That, in brief, my lord, are our submissions.
Communication, the way this was communicated, the way this was raised, yes. Starting with a letter singularly addressed to the court. What is your take?
Well, my lord, I think when we discussed the matter, the previous occasion with all counsel, we reached a certain agreement as to how these matters should be handled. But in this instance, a letter was sent directly to your secretary, and copies sent to the state. Certainly did receive the communication. And I think Mr. Tubane also did receive that communication. But we of the view that perhaps direct communication with the court should be avoided for obvious reasons.
And also maybe to note that Mr. Nzukula, the secretary in this matter, in this court, before this court, because I asked him further after our adjournment, and he did not receive the responses from you and Mr. Tolani. That's what he informed me.
That might be so, my lord, but they were indeed sent. I suppose, we all busy. We spent most of the time in court. It might have perhaps, escaped his attention.
Yes, thank you.
Thank you, Honorable Justice. I do confirm that I will stand with the decision of the court on the previous occasion regarding this matter. The counsel were talking about before the court is a senior person, and if he's not happy with the decision of the court, she knows what to do procedurally, not to directly write a letter to the Honorable Court where there is other parties involved, unlike there is an ex parte application. If there is other parties involved, it's something else. She's not supposed to do that ethically. Furthermore, we submit that with regard to her requesting copies of the docket or transcript from the state, it is also unethical because it will tamper with the other witnesses. It means her client will see what other witnesses will say, and maybe they might even try or attempt to consult those witnesses outside the court. With regard to the issue of her asking for transcript of the bail application, we submit that she doesn't have a local standing, even her client, because it was only accused number 2 who applied for bail, not all the accused. She's wasting the court's time. She needs to draw the line between law and politics. She cannot wake up, she can sleep as a member of a certain party and wake up in the morning as a member of another party. In law, there is ethics and protocol to be followed. She should have done that.
Is that justified? Is there anything political about it?
No, I'm just trying to make an example, Lordship. There's two different, they might think that they are linked, but there are two different aspects. Law and politics are not the same. As I'm saying, you can sleep being a member of a certain party and wake up being a member of another party. In law, there's a line to be drawn. And we therefore stand by our humble submissions, which we do with due respect, I submit that we did reply to the email, the same submissions we're making here today. Unfortunately, maybe they're still in transit, but we did reply to the court clerk. We will object to her request because she didn't follow even a correct procedure. That's the court basis.
Advocate Chololo.
Thank you, my lord. My lord, the application is opposed by the defense for accused number 5 to have a watching brief for Ms. Kelly Khumalo inside this court on the following reasons, my lord. My lord, number 1, each litigant has got the right of representative of his or her own choice. But this freedom is limited when it comes to the complainant and witnesses during the criminal proceedings. Therefore, a complainant and or a witness is not entitled to be represented during the proceedings because he is represented by the state, who is authorized in terms of the Constitution. The state is the only legal representative that is delegated in terms of the Constitution with powers to represent complainant and a witness during the criminal proceedings. Therefore, the witness, Ms. Kelly Khumalo, is not entitled to have a legal representative other than the legal representative, which is the prosecutor before this court, in terms of the constitutional obligations. The interest Ms. Kelly Khumalo is trying to show in this court is going to compromise the trial of this court. My Lord, the further particulars that have been requested in paragraph 1.1, 1.1.1 and 1.1.2 by the legal representative of Ms. Khumalo, she's not entitled to them. It's only an accused person who has been charged who is entitled to further particulars. She cannot demand them, and she's not entitled to them because they will compromise the trial. She can only be prepared by the state before she comes to testify, and as to which information the state is going to use in his preparation, that's the prerogative of the state prosecutor, and she cannot demand that right. Lastly, my Lord, the prejudice that she is saying that she will suffer if her legal representative is not admitted in this court. There is no prejudice that will be suffered by Ms. Kelly Khumalo if her watching brief is not allowed in this court. Instead, the prejudice will be suffered by the accused before this court. Because in other words, she's demanding to have information before she comes to testify, my Lord, which is not allowed in law. Above that, my Lord, this case is broadcasted, my Lord. That on its own has compromised this trial because they are watching, they know exactly what is happening in this court, but we have no control over that, my Lord. Above that, she still wants a legal representative for herself to come and sit here. For what good reason, my Lord? That will prejudice the accused, my Lord. Lastly, my Lord, the way in which this matter has been communicated directly to His Lordship is wrong and is not allowed. Ms. Munsami is a legal representative who knows the procedure, who knows the ethics on how to communicate with the court. It is worse when it excludes the legal representatives of other parties during the proceedings. Therefore, my Lord, those are my submissions that this application should be refused and not be entertained anytime in future because it's just wasting the court's time when we're supposed to be proceeding with the trial in this matter. Let them watch outside, watch the television, and follow the proceedings at home. Those are my submissions, my Lord.
Can I just only add one aspect, my Lord, that a witness is only entitled to a copy of his or her statement, and the witness in question has already been furnished with a copy of her statement, including her attorney. Both have been furnished with copies of her statement.
in this matter, there is a ruling in place. I don't intend to make another ruling, save to give a direction that the ruling has already been made in this matter, which still stands, is going to be abided by all of us in this case. I also raise a concern. I think it will be directed to Ms. Munsami by the Secretary, Mr. Nzukula, about the way this issue was communicated. I expect an advocate not to be serving pupillage in court. I expect her to know this and not to rely on courts to tell her how to do things. The position of an advocate is one that is very, very, very notable within our system, especially within the court proceedings. And I wouldn't have expected Ms. Munsami to have to be reminded about how to communicate and things of the sort. But I think I will request Mr. Nzukula to communicate with her, to remind her and to note that, to notify her that the court stands by the ruling it has made, and also that all of the parties involved are of that view that the ruling already in place should rule the day without any changes, since nothing has changed ever since that ruling was made. It is now tea time. We'll adjourn for tea, and then we'll return to start with the proceedings proper.
Mr. Court,